Can the government take your land just because it doesn't like you? That's happening to Brinkmann's Hardware, a beloved local store in Long Island. After a lengthy fight, the town of Southhold, New York is now trying to take their land away through eminent domain, all to protect another business from competition. Today we're talking with Hank Brinkmann and IJ senior attorney Jeff Redfern about how Brinkmann's Hardware went from a small family shop to a champion of property rights, and their path all the way to the Supreme Court. This is Beyond the Brief. So Hank, let's start at the beginning. Can you tell us a little bit about, what is Brinkmann's and what does it mean to your family?
Sure, yeah. Brinkmann started in 1976 when my mother and father founded their first store in a little town, Southhold, New York, a little rental space. It started in just 2,200 square feet, and they've been expanding ever since. As kids, we grew up in the business. They would bring us to work and put us in the back room as, they were the only two employees in the store. So on the weekends, my brother and sister and myself would all go to work, and we'd be in the back room playing in the hardware store. And, eventually a broom was put in our hands and we'd start sweeping aisles. And then we wound up just growing up in the business, working there through middle school and high school and into college. And then after college, my brother and my sister and myself all came home and got more involved in the business. And about 10, 12 years ago, we bought our parents out and had a vision to really grow the business and add more stores. And yeah, we love it. We love what we do every day. We love going to work, and it's great. Our mom still comes to the office every day, and it's a nice family atmosphere in the office. Yeah.
It sounds like a true family business. How many locations do you guys have now?
So we have 6 locations now, and yeah, we're looking to grow. We're always looking for new opportunities, and I think that's the part of the business that we like the most is growing it and seeing how big we can get and where we can take it. And yeah.
And, everybody kind of thinks of like their, neighborhood hardware store with the, helpful guy in the back who knows where everything is and knows how to fix all the stuff. And that's you guys, basically, right?
Sure. Yeah, we pride ourselves on that, and being part of the community and being that place for the community to come when they need something. And as well as, I love it when customers come in and they see other customers they haven't, other people in the neighborhood they haven't seen in years. And there's a lot of reunions in a hardware store, a little local hardware store has a lot of that,
Yeah, I love that line. There's a lot of reunions in a hardware store.
Yeah.
That's not a thing that you'd think about unless you, owned a hardware store.
Sure, yeah.
So you, started to expand and things like that and ran into some trouble in one of those expansions. So can you talk a little bit about that?
We did. So we have in our business, we had some standalone paint stores, and our vision was to bring those standalone paint stores in line with and join them with hardware stores to expand the footprint and make it a bigger offering. And we have our last single standalone paint stores in a little town in the North Fork, Jamesport, New York. And we found a piece of property about a few miles down the road, a beautiful corner location, and it was vacant. There was nothing built on it, and I remember seeing a for sale sign on there when I had been driving out there years prior, and but we weren't in the financial condition to be able to move on it. But then later on, a few years later, when we were looking to expand and we were looking to move that paint store and bring it in with a hardware store, and we were looking to build in the area, I remembered that property, and I remembered seeing the for sale sign on it. I said, I wonder whatever happened to that. So we looked it up. My brother and I looked it up, and we found that it was owned by a bank, and we called the bank just out of the blue, and they weren't doing anything with it, and we got a response that it was actually surplus real estate for them, and they didn't need it, and it was and they'd be willing to entertain offers on it. So we made an offer on it, and about 2 weeks later, we had a deal to buy the property, and And then, the first thing we did was approach another local business in town that had a hardware store there. And
yeah, so, at what point did you kind of run into trouble? It seems like this is, a smooth transaction. You buy this property from the bank. It's, easy. So how'd you end up?
Right. So everything was going great. We bought the property from the bank, and we had known a local business owner in town who has a hardware store there. And obviously there would be overlap in our businesses. And, we didn't want to see, conflict if there didn't have to be. So we approached them. We went in there and wasn't sure if he was going to throw us out of the store or if we were going to have a nice conversation. And our idea was to try and find some mutually beneficial way to work together. So we approached him, and he was open to it. He wanted to think about it, but basically we offered to buy his business and then have him come work with us and manage our new location. And he liked that because his location it had been a hardware store for, I don't know, 100 years or something, and it doesn't have any parking, and it's not conducive to modern retail. So I think he liked the idea of having a bigger, wider offering, and with parking and all the things that you want in a retail business. And so in the end, we were able to, over the course of a few months, we were able to make a deal, and we had a nice handshake agreement on moving forward together. We were going to buy his store, and upon finishing construction of our new building, he would close his store, and he would come manage our new store.
So it sounds like you did all your due diligence. You worked with the other guy in the community and everything, and still seems kind of like smooth sailing a little bit.
Absolutely. And that was only half the equation. The other half of the equation is making sure that we're in compliance with our application on our new building. And that's why we like this property. It was commercially zoned. It didn't need, we didn't need any relaxations or variances to do what we wanted to do with the property. And it was a great corner exposure right in the middle of the commercial district and in the middle of town. It was perfect.
And then the town itself has something to say about this.
And then, a couple months go by and we don't hear from this other business owner down the road that we had a friendly deal with. And we get a call from an ex-town attorney that worked out in that town. And he let us know that unless we doubled our offer to this other business owner, that we would not get past our insurmountable hurdles in getting a building permit for our new location. And that's when we knew there's going to be some problems.
What are these insurmountable hurdles?
Well, that's just it. We didn't have any. So our application was 100% in compliance. We needed nothing. We were able to hit the parking, the green space requirements, the parking requirements, the setbacks, everything. We were able to go in 100% as of right with our application.
And just to give some context, you've expanded your location before multiple times. You have 6 locations now. How long did it take you to get those other applications, those other expansions from idea to opening in terms of time?
Right. So the application process on Long Island in New York, it can be difficult, but it's typically a 2-year process. And after about 4 or 5 years here, we were at a standstill with the town actually moving to seize our property through eminent domain.
So more than twice as long as any other location you guys have opened up, just to give context.
Right.
Well, and your newest branch opened recently, like while you're, not to kind of spoil things, but while your lawsuit has been going on, you've opened a new location, right?
Right, we did. Our biggest one yet. Very proud of it. It's doing very well. So it's our biggest offering yet, a 30,000 square foot store. And that one, we moved through that process in less than a year. We had it from contract to open.
So was it the competitor in this case that's trying to prevent you from moving into the town? Was it city officials who independently decided we don't want this new hardware store opening? How did that sort of play out over these 4 or 5 years?
It's interesting. I don't quite know, but it's a combination of the two. and I'm inclined to say that it was the competitor, the guy that we had a handshake deal with. He's a nice guy. He really is. Nice, nice guy from nice family. I think he was persuaded by others somehow to kind of, throw that claim at us and extort us for, $350,000 to get him our building permit.
So, Jeff, he had mentioned, this permit thing, and then at some point the town takes the land. How do you even get from the one to the other?
Well, it was a long process. I think what really happened was the town realized that it was running out of options to stop them from opening their store. Because eminent domain was not their first resort. They imposed some pretty exorbitant fees. They wanted you to do this municipal impact study, and I believe that was $30,000.
$30,000, yeah.
To study the impact that this hardware store will have on the local economy. They did a traffic study. At one point, the city imposed a building moratorium, or what they called a building moratorium, but it was centered right on their property, and then they gave everyone else exemptions during this period. And the Brinkmanns, they sued to get this building moratorium thrown out, and we weren't involved with that lawsuit. That was before us. But they were doing pretty well in state court, and it looked like the town was going to lose. And I think that's when they came up with this new plan to seize the property via eminent domain for what the town called a passive use park, which I guess is a park that you don't do anything with. It you leave as vacant land.
So can you first kind of explain, some folks listening will be aware of this, but can you briefly just kind of explain what is eminent domain?
Sure. Eminent domain is the government's power to seize private property for so-called public uses. And we've litigated a lot of cases about what constitutes a public use. Certainly things like roads and parks have traditionally been considered public uses, ferries, bridges, military bases, public schools, things like that. And the government can take your property for those things. It has to pay you fair market value. The problem in this case, though, is that even though a park is a public use, the park isn't the reason that the town was taking the property here. The reason the town was taking the property is to stop the Brinkmanns from opening their hardware store. And we know this not just because of this incredible timeline of things that the town did to try to stop them, where the park was just the last resort. We can also look at the town's own documents. They have a list of about 1,000 properties that they have targeted for potential future acquisition for other town public uses. Their property wasn't even on it. So this is a small town. They had a list of, these are the 1,000 properties we might at some point in the future think about taking. And this didn't even make the top 1,000. This is not, a normal planning process where you're thinking about, hey, we want a park. Let's have maybe the parks department would be involved with something like that. You would think.
That sounds like a
yeah. That's not how it happened here. There are no plans. There's nothing written down. There's no site plan. There's no thought going into what will this land look like. They just said, look, if we just say we're taking it for a park, that'll be the end of it. And courts can't second guess that, or that's what the town thought anyway.
Well, and you had earlier described this as a passive park. What does that even mean?
I think that means that they're not going to do anything with it, that they're going to leave it as vacant land. And we've seen this in other cases around the country. It's the cheapest thing to do if you want to take someone's property. To say, well, this is technically parkland, but we're not putting in playgrounds and drinking fountains.
We're spending no money to make it be a park.
Right.
Yeah. It's just, it's basically just a wooded lot, right?
Right, exactly. Yeah,
It's almost the opposite of Parks and Rec. I mean, in Parks and Rec, you had an empty lot that Leslie Knope was trying to build into a park, and here you have an empty lot that the city just wants to keep an empty lot and call a park.
Exactly.
Has the city ever given a reason for what they're doing? I mean, it's kind of obvious at this point that all of these excuses are pretextual. But, I mean, aside from maybe a desire to protect some, important person's hardware business from competition. I just don't understand why the city is putting up such a fight here. I mean, it's not as though the Brinkmans are trying to put up a strip club next to an elementary school. I mean, this is just a hardware store. This is something that you can find in every community across the country. What has the city been saying, either in public or behind closed doors?
Well, you probably know better than I do why they want to stop you. It seems pretty mysterious to me.
Yeah, and I think it's all about the competitor that's down the road. They're just trying to protect a friend who's in a similar business, and the government shouldn't be in there picking winners and losers. That should be, decided through fair competition.
And that you and your family already had a presence in this community, right? You had a paint store a little ways down the road, so
right.
Folks in the area are familiar with you. And what was kind of the reaction in the town itself, not the government, but just the regular people in the town?
By and large, we had overwhelming support from the community. We have a lot of customers. We've been doing business in that town since the early 2000s. So it had been, close to 15, 20 years by the time we presented our application. And in fact, after this all came out and we were very publicly fighting this eminent domain and even the building moratorium and whatnot, we got overwhelming support, and our business in our paint store just down the road skyrocketed because people were coming out to support us. So it was clear that we knew that it was a select few of the decision makers in town that were keeping us from opening our business.
So why this particular piece of land? I mean, there's a lot of questions about, why does the city want this particular piece of land, and that there's a piece of land right next to this that the city could use, or that you could use. So can you talk a little bit about, why is this centering so much around this one specific parcel of land?
Well, the city wants this piece of land for no other reason than to stop us from building our store. And, for instance, if they really needed a park in the area, they could buy the property that's directly adjacent to ours. It's a vacant parcel. It'd be perfect for a park, and it happens to be listed for sale in the open market right now, and has been for years.
So the city, just to make sure that I understand what's happening here, the city looks at two adjacent pieces of vacant property. One is owned free and clear by you guys, and you have plans to build something on it. And then another one is actively for sale, and they choose to take yours instead of to just buy the for sale one and make it be a park.
Exactly. That's what makes their motives so clear.
Yeah, that's crazy. So how do the local officials justify this? Like, how are they pushing so hard on it?
Well, it's so transparent that they haven't really denied what's going on here. That's the extraordinary thing about reading all the briefs in this case, is that they basically admit, yeah, we took this property in order to stop them. They just said, as long as we put a passive use park on it, i.e. as long as we do nothing with it and allow the public to, I guess, walk in the woods there, then courts have no role in second guessing what we're doing. It doesn't matter why we're doing it as long as the end result is a park. So that's their theory. And they haven't really tried to justify why they're stopping the Brinkmans. They don't think that they have to.
Do courts buy this theory of, you can straight up say that it's to stop these people, and as long as you do something ostensibly public with it afterward, then, the court can't look at it at all?
Not until this year they didn't. There are cases around the country. Even there's a New York State case from the 1960s. There are cases from a whole bunch of state high courts looking at cases that are remarkably similar to this, where you have people who are trying to do something with property they own. It's something that's totally lawful. It complies with the zoning and all the other requirements. But for whatever reason, the locals just don't want it there. And then they use eminent domain to take this property, usually for a park or a passive use park, something like this, because it's the cheapest thing to do with property that normally qualifies as public. And the courts over and over again said you can't do that. Stopping someone from making a lawful use of their property isn't a public use, and you can't launder it through making it a park on the back end. The Second Circuit, unfortunately, became the first court ever to disagree with that and said it actually does not matter why they're taking it. The weird thing about it, though, is that they admitted that there's a little carve-out. So if they're taking private property and you're making a park, but the true purpose of taking it, according to the Second Circuit, is to benefit a private party. So let's say I'm taking your property and I'm going to put a park on it, but the reason I'm doing it is because my buddy just put up a bunch of townhouses across the street, and they'll be more valuable if there's a park there. That would be unconstitutional, according to the Second Circuit. But if they're doing it because they don't like the Brinkmanns or they don't want a hardware store or something like that, that's perfectly okay. Then we can't look at the motives. But we can look at the motives if it's to benefit a private party, which is awfully strange to me, and it's certainly not what any other courts have ever held.
Well, and it seems like that's also exactly what's going on here, is they're taking it to benefit a private party. I mean, sure, it's not the same as, a park here would raise the property values in theory of these townhouses across the street, but it's, we're not going to let you build a hardware store so that this other guy doesn't have to figure out what to do with his own hardware store.
That's right. Yeah.
So how did they just kind of ignore that that's also a private party?
Well, the town was able to sort of throw up some other arguments about, maybe this hardware store is too big and we wouldn't have zoned it this way, but we, didn't get our act together. So, they threw up some other possible reasons that they wanted to stop the hardware store, but they didn't deny that the whole point of this was to stop the hardware store. And that's what all of these other courts, up until the Second Circuit decision this year, they all said you can't do that. You can't stop someone from making a lawful use of their property. Now, everyone knows that local government has really broad authority when it comes to things like zoning and permitting. You said the normal process is 2 years. That's not like a rubber stamp. It's not easy to open a new store on Long Island. But normally the rule is you can look at the rules. You can see what the zoning ordinances say, and you can figure out in advance before you spend a fortune on a piece of property, am I going to be able to do the thing I want to do with this? And these are known and they're public and everyone can figure this out. But the town's theory is basically that even if you jump through every one of these hoops, you comply with the zoning code and you hire a local architect and you do your municipal impact study and you do town meetings to address everyone's concern about how the hardware store should be laid out with the intersection. All of these things, at the end of the day, the town still has this final veto. They can always say, you know what, we just don't want you or this business. We have basically unreviewable discretion to veto any particular use. And that's not how land use law has ever worked in this country before.
Jeff, when people think about eminent domain and they think about IJ, they often think of Kelo versus New London, the landmark case that we litigated now almost 20 years ago. Does this cert petition ask the court to reconsider that case? How is it related to that case, if at all?
This decision doesn't ask the court to reconsider Kelo. It's related in that they're both about what public use means. And if the court were to deny this and allow the Second Circuit decision to stand or to grant and God forbid, affirm the decision below, that would really be an extension of Kelo. It would be saying, look, public use is not only reviewed very deferentially, but ultimately we don't really care why the property is being taken at all. And this is significant because Kelo actually had a carve-out in it. There's language in Kelo saying, okay, they're taking this property for so-called economic development. They're going to give it to another private party who's going to pay more taxes. And we think that's a public use, according to the court. Obviously, IJ disagrees very strongly with that. But the court said, of course, it would still be unconstitutional to take property under the mere pretext of a public use when the true purpose is to bestow a private benefit on a private party. And this language was recognizing basically all of these cases from around the country, going back decades and decades, really, to the early 20th century, saying that you can't use eminent domain in bad faith. The reason that you say you're taking property has to be the real reason that you're taking property. So the court, if anything, was reaffirming that, and we're going to ask it to say, yes, that is still the law. The Second Circuit thinks that it's limited, as I noted before, to just allegations of private benefit. We think it's broader. We think that cases around the country have recognized that it's broader. In particular, the Connecticut Supreme Court actually looked at a case that's almost identical to the Brinkmanns. And it said that under federal law, that's unconstitutional. You can't take private property. In that case, it was to stop an affordable housing development. People didn't want to have affordable housing in their neighborhood, so they said, let's get some playing fields. But it wasn't through the normal process. Somebody just basically drew some playing fields on a napkin and said, that's what we're going to do. And the Connecticut Supreme Court said that that was unconstitutional. So if the Supreme Court doesn't take this, that means that in Connecticut, you don't actually know what your property rights are because the Second Circuit contains Connecticut. So if you've got property in Connecticut, whether you have protection against these kinds of takings really just depends on whether you end up in federal or state court.
So when you, Hank, found out that you're, filing this petition to the U.S. Supreme Court, what was going through your mind? What did you think about that?
I was very excited to still have an avenue to fight this. So yeah, we were we're very grateful of IJ and just to have somebody in our corner to kind of fight for us. If it wasn't for IJ, this thing would have been over a long time ago. There's just we could have never afforded to put up this kind of fight. So yeah, we were just very grateful for IJ every step of the way, and especially after the decision came down from the Second Circuit that we were just going to keep fighting, and so yeah, it's nice to have IJ in our corner, and a win will be very gratifying.
How did you find IJ, by the way?
We didn't. IJ found us. Yeah. It's I still remember the day my brother and I were. We often have lunch out on the road, and we'll we visit our stores, and we have lunch before we visit our stores. We'll park across the street and just watch the parking lot and watch the customers and watch our staff interacting with people and see what customers are buying and whatnot. And we were sitting across watching one of our stores one day, and the phone rang in the truck. Actually, my cell phone rang in my pocket, and I had a sandwich on my lap, so I didn't answer. And then my brother's phone rang, and it came over the truck. So he said, "Oh, it's the same number. That's strange." So, so he hit the button and picked up the call, and that was IJ. That was a reef calling, and yeah, it was kind of a very unusual call to get, as you can imagine. We were very guarded in the beginning, but as Arif kept explaining, and we were curious as to the motives and how could this be that somebody wants to fight this on our behalf pro bono, and but then after some research and looking into IJ, we realized how lucky we were to get that call. Yeah.
What are you hoping? I mean, obviously, we hope the Supreme Court takes it, and we hope we win. And what are you hoping happens after that?
To build a big, beautiful hardware store on that corner. Yeah. Yep. Yeah. Nothing would make us happier. That's that's all we want. To just fulfill our dream. We bought that piece of property. We couldn't believe that we were buying that piece of property. We had looked at it years before, and it was out of reach for us. But after some more, years of hard work and some sacrifice and saving, and we were able to make it a reality. And it was it was coming to fruition. We had the plans drawn. The architects had the whole thing. You could actually see it in your mind. You could I could picture it on that corner. And so, yeah, we're still hoping we get to build that store there one day. Yeah.
Jeff, we know that, when you ask the Supreme Court to take up a case, it's a long shot. There's a very few number of these cases that are granted. What gives you optimism that this is going to be one of the ones?
I think there are a few reasons that this is a promising vehicle for Supreme Court review. The first is that there's this split of authority. The number one thing the Supreme Court is thinking about when it takes cases is whether it needs to resolve a split. And this has that particularly pernicious split where it's Connecticut versus the Federal Court of Appeals, Second Circuit. Those sorts of state versus federal appellate splits are considered a high priority to get resolved. Another issue is that we have a fantastic dissent in this case from Judge Menashe. Clerks are busy. They have a lot of petitions to read, and they know that every lawyer is going to try to suggest that their case is a really, really important one where something outrageous is going on. But they pay a lot of attention to what a federal judge says. And if a federal judge says, look, there's a split of authority, it's a real split of authority, and the majority has done something crazy, that's going to get a lot of attention. So I think that the dissent makes this a particularly strong vehicle. And we also just know that the Supreme Court has been very interested in property rights and in the takings clause in particular in recent years. They're taking a takings case just about every year lately. And this seems like it could be the next one. Also, I think the fact that all of the cases went our way until now is very helpful because the Supreme Court wants to know that it can decide the case in a way that will establish a rule that will be easy to administer. And because we can look at decades and decades of practice under this other rule, we don't have to speculate like, oh, are we going to, upend the apple cart and is there going to be chaos? There's not going to be chaos because we're just asking the court to rein in the Second Circuit and go back to what the rule was before. And we know that this has been easy to administer. We know that it hasn't been, unpredictable. And there's every reason to expect that they can just look at that as sort of a path for how to decide this.
You said that, there's all these other circuits that have done this the correct way and that the Second Circuit is kind of to me, it sounds kind of like an anomaly. And so is there any reason to worry, oh, this was a horrible thing that happened to Hank and his brother, but, it was a one-time thing. It's not going to happen to anybody else. So maybe it's fine. Is there any reason to think that?
I don't think so. So the cases that went the right way are pretty much all state Supreme Court cases, which is not unusual because usually eminent domain cases are litigated in state court. New York has weird procedures, and that's why we ended up in federal court. But I think the Supreme Court cares a lot about what federal courts do in particular. Second Circuit decisions, a reported Second Circuit decision that's recent, that's going to be cited. It's going to be followed. People are going to read it, and it has the potential to be very influential. So I think it's a dangerous decision that it should be important for the court to set straight.
Hank, as I'm hearing your story now, sitting across the table from you, my blood is boiling. And none of this happened to me personally. I can't imagine how frustrating it was for you to have to deal with this when it's your property, it's your business, it's your dream, and you're having to face all of these obstacles that the city is raising, that this competitor is raising. How on earth did you summon the patience and the persistence and the courage to continue fighting through this time after time after time?
Yeah, well, I think, it's your only choice, right? So you're left with no other choice. You can either roll over or you can fight, and I think that we're much like many other small business owners out there across all of America that that you get up and you go to work and you believe that if you do the right thing and you work hard and you sacrifice and you have some discipline, that you should be able to carry out your dreams, and that's what we're doing here. And I guess that's what keeps us fighting is the belief that if we give up, we're making it easier for them to just do this to others in the future. And I just think that would be wrong, and not only for us, but for everybody else. Yeah.
Well, thank you so much for, being the bulwark against this government abuse and, on behalf of yourselves and everyone else that could experience the same kind of thing. And thank you to both of you for coming in and talking with us today, and good luck at the Supreme Court.
No, absolutely. Yeah, anything we can do to help, we're all in. We appreciate IJ.
That's it for today. Thanks again for watching, and don't forget to subscribe.